Welcome to the September 2019 Commercial Law Update podcast by Eversheds Sutherland. I'm Sarah Ellis and I'm joined by my colleague Claire Stewart, and we're Principal Associate Professional Support Lawyers. Before we start, please can I draw your attention to this disclaimer. Today we're going to be looking at 4 different things. Claire's going to give you an update on where we are on Brexit. Then I'm going to look at the new Incoterms 2020 and the recent Law Commission report on e-signatures. And finally, Claire will look at a recent case on good faith. So I'll hand over to Claire now for the Brexit update.
Thanks, Sarah. Now, for our Brexit update, I've headed this first slide, legal challenges to political events. But the first point is what we might call a parliamentary challenge rather than a challenge through the courts. The European Union Withdrawal No. 2 Act is the no-deal private members bill which has now received royal assent. This is the act that imposes a legal obligation on the Prime Minister to request a third extension to the Article 50 period until 11 p.m. on the 31st of January 2020, unless, by the 19th of October, the government has obtained Parliament's consent either to a withdrawal agreement or to a no-deal exit. It also says that if the European Council proposes a different end date, the Prime Minister must either accept that different end date or ask the House of Commons whether it approves the new date. However, it's worth remembering that whatever UK legislation says, any extension requested by the Prime Minister also requires a unanimous decision of the European Council. Then we have court challenges to prorogation of Parliament, the suspension of Parliament. Right now, the UK Supreme Court is hearing 2 appeals on the lawfulness of this prorogation. If the Supreme Court decides that prorogation was lawful, then Parliament will remain suspended until the 14th of October or until the government decides to advise the Queen otherwise. If the Supreme Court decides that the prorogation was unlawful, then there are more than one possible outcomes, and we are second-guessing here. One possibility is that the court compels the government to bring back Parliament and start a new parliamentary session immediately. Another is that the court rules that the prorogation was a nullity and so never happened. If this occurred, then there would be no new state opening of Parliament and no new Queen's speech setting out the legislative agenda of Boris Johnson's government. And the previous session of Parliament would continue, with the unfinished Brexit bills coming back into play. So in terms of impact in the context of Brexit, a successful challenge means that the House of Commons will have a bit more opportunity to scrutinise the government's Brexit policy and may be able to pass further motions to seek the publication of internal government documents. And if prorogation is ruled to be a nullity, then unfinished Brexit-related legislation, which fell at the point of prorogation, would be able to continue its passage through Parliament. You may remember that in the context of Brexit, this includes a trade bill setting out the UK's new independent trade policy, an immigration bill and a bill relating to financial services. The timetable for the Supreme Court hearing is that it started yesterday on Tuesday the 17th of September and it will hear submissions until the end of Thursday the 19th of September. Now we might get an oral judgment on Friday, but probably not a full reasoned written judgment until the following week. However, as at the date of this recording, we do not have a judgment of any kind. Next, I'm going to look very briefly at the government's no-deal planning. After parliamentary pressure, the government recently released a 5-page document related to its no-deal planning, which contained what it called reasonable worst-case planning assumptions, and then also key planning assumptions. The reasonable worst-case planning assumptions include a restatement of some of the positions that we are already aware of, such as a reminder that in a no-deal, all rights and reciprocal arrangements with the EU end, and the UK reverts fully to third country status. The document then goes on to say that its reasonable worst-case planning assumptions include the following. Firstly, the relationship between the UK and the EU as a whole will be unsympathetic, with many member states unwilling to engage bilaterally and implementing protections unilaterally. Secondly, that no bilateral deals will have been concluded with individual member states. Thirdly, that EU citizens living in the UK can retain broadly all rights and status that they were entitled to prior to exit from the EU, but of course this doesn't mention the steps that these citizens need to take to ensure this occurs. Fourthly, that public and business readiness for a no deal remains at a low level and will decrease to lower levels because of the absence of a clear decision on the form of EU exit. Fifthly, that business readiness will not be uniform and compounded by seasonal effects such as warehouse availability. The document then goes on to make some key planning assumptions, of which I can pick out a few. For those of you involved in sales of goods contracts, for freight flow and traffic management, 31st of October is a Thursday, so day one of exit is a Friday and coincides with end of October half-term school holidays. The worst disruption will be to the short channel straits, and that might last up to 3 months, this document says, and reduce flow rate to 40 to 60% of current levels. In a reasonable worst-case scenario, HGVs could face maximum delays of up to 2.45 days before being able to cross the border. However, the risk, the government says, is lower at ports outside Kent. They say that demand for energy will be met, but significant electricity price increases are likely. They mention the reliance of medicine and medical product supply chains on the Kent Short Straits crossing, making them particularly vulnerable to severe extended delays. It says that critical dependencies to the food supply chain, such as key ingredients, chemicals and packaging, may be in shorter supply. There will be reduced availability of food and choice of products will result and increased prices. They say that the EU will not have made a data decision with regard to the UK before exit in terms of personal data transfer. This will disrupt the flow of personal data from the EU, where an alternative legal basis for transfer is not in place. Interestingly, this document says that in a no-deal situation, an adequacy assessment could take years. In relation to the Irish border issue, the document states that on day one of no deal, the government will, what they say, operationalise the no new checks of limited exceptions model, which was announced in March by Theresa May's government. Excuse me. This establishes an interim legislative framework for essential operations on the ground to avoid immediate risk of a return to a hard border on the UK side. But this document says that this model is likely to prove unsustainable. With the UK being a third country, the automatic application of the EU tariff and regulatory requirements for goods entering Ireland will severely disrupt trade, with the expectation that some businesses will stop trade or relocate to avoid paying tariffs, with the agri-food sector being the hardest hit. Now, other than a brief reference to financial services in this no-deal planning document, this document makes no mention of services. And you can see from this summary that I've given you that its focus is really on goods and citizens' rights. As part of the no-deal planning, the government has launched its Brexit readiness events. If you are interested in attending a Brexit readiness event, I've put the details on this slide. There will be advice stands covering issues ranging from the importing and exporting of goods, exporting services, how to employ EU citizens and businesses that transfer data. There will be government advisors from a variety of ministries available. But just a word of warning though, these events are quite short, some are often only 2 hours, and some are already fully booked. So I'll now pass you back to Zara, who will discuss our next topic for today.
Thank you, Claire. So I'm going to talk to you now about Incoterms 2020. So the International Chamber of Commerce has now published these, and they'll come into force on the 1st of January next year. Incoterms are a standardised set of international trading terms which can be incorporated into a contract for the sale of goods to define certain obligations on the part of both the buyer and the seller. They're not a complete contract of sale in and of themselves though. The key areas they cover are set out on the slide. So the obligations, who does what as between seller and buyer. So for example, who organises carriage and insurance of the goods, who obtains shipping documents and export and import licenses. They also deal with passing of risk. Incoterms use the term delivery to mean not physical delivery of goods, but the point at which risk in the goods transfers from the seller to the buyer. And they also cover costs allocation, so which party is responsible for which costs, for example, transport, packaging, loading and unloading costs. There are many things that Incoterms don't cover, for example, including the passing of title to the goods, pricing and payment, specification and quality of goods, force majeure, remedies for breach of contract, and governing law and dispute resolution. There are 11 different sets of Incoterms, each of which is denoted by a three-letter acronym. When you're incorporating an Incoterm into a contract, you should refer to it by the three-letter acronym, then a named port, place or point, followed by the words Incoterms 2020, making it clear, of course, which version of Incoterms you're referring to. The place is very important. In all Incoterms other than the C rules, the named place is where the goods are delivered, so where risk passes from seller to buyer. In the C terms, it is the place to which the seller must organise and pay for the carriage of goods. There are two key ways of grouping the Incoterms in order to understand their key differences. The first is to look at them by reference to delivery points, with on the left-hand side of the slide, E or X works providing for the delivery point, so the point of risk transfer, to be before transport even starts because the buyer is obliged to collect the goods. And at the other end of the spectrum you have the D terms, where risk transfer is late, with the delivery point being the destination point to which the seller or its carrier carries the goods. So E is the minimum level of obligation for the seller, and D the maximum. The other way of looking at them is to group them by mode of transport. So I've identified the 4 Incoterms on the slide which apply only for transport by water, and the other 7 which can be used for any mode of transport. In creating the 2020 version of Incoterms, the ICC has sought to give better and clearer guidance on selecting the correct Incoterm and the obligations that are defined by each Incoterm. They've reordered the articles in each Incoterm in order to make the sections on delivery and transfer of risk more prominent and to make clearer the connection between the sale contract and the ancillary contracts of carriage and insurance, and if applicable, letters of credit. Each term is now set out in the order that I put on the slide, with the A articles setting out the seller obligations and the B articles the buyer obligations. There are also plenty of visuals to make it clear which obligations each party has under each Incoterm, and to enable the user to compare the differences between each term more easily. In addition to the presentational changes, there are various substantive changes that have been made. These include the following: bills of lading with an on-board notation and the FCA rule. Under the FCA rule, there's now an option for the parties to agree that the buyer will instruct its carrier to issue an on-board bill of lading to the seller after loading the goods, even though the risk transfers before loading. Cost listings. In the 2010 version of Incoterms, the allocation of different types of costs was mentioned against the relevant obligation, which meant that references to costs are peppered throughout the Incoterm. In the 2020 version, this has changed, and all costs allocated by a particular Incoterm will be referenced again in Article 9 of that Incoterm. There are different levels of insurance cover in SIF and SIP. Essentially, under SIP, the seller is now obliged to obtain a higher level of insurance cover than under SIF. Arrangements for carriage with own means of transport. In FCA, DAP, DPU and DTP, in the 2010 version, it was assumed that carriage of goods would always be undertaken by a third party. But in the 2020 version, these rules allow for the carriage of goods to be undertaken by the buyer or seller itself or via a third party carrier. DAT, delivered at terminal, has been changed to DPU, delivery at place unloaded, and security-related requirements have been given more prominence and added to carriage obligations and costs. Businesses should be reviewing existing contracts that use Incoterms 2010 to ascertain whether they remain fit for purpose or whether they should be varied to incorporate an Incoterms 2020 rule from the 1st of January. There's no reason in principle why you can't keep on using Incoterms 2010 from January. But firstly, if you're going to do this, you need to make sure that the contract makes it clear that this is the case. And secondly, bear in mind that as the Incoterms have been modernised, it may be that a new term is actually more appropriate. And of course, it's prudent to review existing use of Incoterms with a Brexit hat on, as the assumptions that were originally relied on in selecting the original term may no longer hold true. Also remember the 2 key points when considering a contract that incorporates an Incoterm. Firstly, ensure that it's the correct Incoterm for the transaction, and secondly, ensure that your contract terms work with the Incoterm, that they speak to each other and don't conflict. I'm now going to move on to our next item. So earlier this month, the Law Commission published its report on the electronic execution of documents. Its brief was to review the law in this area, particularly with regard to the validity of e-signatures, and to consider whether legislation is required to ensure that organisations and individuals can use e-signatures with confidence should they wish to do so. And it was recognised that for so long as there is doubt and suspicion about the use of e-signatures, this can slow down transactions and lead to disputes about the validity of documents. The Law Commission report concluded crucially that an e-signature is capable in law of being used to execute a document, including a deed, provided firstly that the person signing the document intends to authenticate the document, and secondly that any formalities relating to execution of that document, for example that the signature be witnessed, are satisfied. Note that this applies to both commercial and consumer documents, and in principle to all other types of document, with the exception of wills and dispositions of registered land. Note also that the report only applies to England and Wales. Secondly, the report concluded that an e-signature is admissible in evidence in legal proceedings. And it's noted that there's a distinction between legal validity of an e-signature and its evidential weight. In other words, if there's a dispute about, for example, who signed the document or whether they intended to be bound, technical evidence may need to be adduced. And it's also noted that both security and reliability of different types of e-signature will be a significant issue for the parties. The report concludes that save where provided to the contrary by legislation, case law or contract, no particular form or type of e-signature is prescribed, and the report is technology neutral in that it doesn't promote any particular type of e-signature or any e-signature platform provider. And finally, the requirement under the current law for a deed to be signed in the presence of a witness requires the physical presence of that witness, the report concludes, even where both the person executing the deed and the witness are executing using e-signatures. As well as the conclusions, the report contains a number of recommendations. It suggested that although the existing law provides for e-signatures, government may wish to consider codifying this area of law in order to improve its accessibility and to remove any remaining doubts which inhibit the use of e-signatures. It also suggests that an industry working group should be formed to consider practical and technical issues relating to electronic execution, and that this group should be looking at issues such as how different technologies can help provide evidence of identity and intention to authenticate when documents are executed electronically, security and reliability of different technologies. It can produce best practice guidance and can consider potential solutions to the practical and technical obstacles to video witnessing of e-signatures on deeds. Following the work of this working group, the recommendation is that government should consider using the Electronic Communications Act to allow for video witnessing. And finally, the report recommends that the government should ask the Law Commission to carry out a review of the law of deeds in general, to consider whether the concept remains fit for purpose, and to include a consideration of whether the implications of the Mercury case should be codified for both paper and electronic deeds. I'm now going to hand back to Claire, who will deal with our last item.
Thanks, Sarah. So our last item is a look at another case on good faith in commercial contracts. In April, we reported on a High Court case that implied a duty of good faith into a commercial contract, with the result that a party may be potentially restricted in the way it acts in exercising its contractual rights. That case was Alan Bates versus the Post Office, where the judge decided that there is an established category of contracts in English law called relational contracts, where there is implied an obligation of good faith, and this is implied not as an individual term necessary to make sense of the arrangement, but as incidental to the very nature of the contract. We now have another High Court case looking at the argument of whether an obligation to act in good faith should be implied, that of STI Retail Services and Rangers Football Club. This later case arose from a widely publicised dispute between Rangers Football Club and Sports Direct, arising from a retail and distribution agreement which allowed Rangers the freedom to do deals with third parties if it gave Sports Direct a right to match third-party offers. The trouble was, when the contract was put into practice from the point of view of Rangers, if Sports Direct was able to exercise its matching rights repeatedly, this gave Sports Direct far greater power over Rangers' entire supply chain than, Rangers said, was intended. So Rangers argued the agreement was a relational contract, and therefore when Sports Direct sought to exercise its matching rights on more than one occasion, it was subject to exercise them in a way to act in good faith. If this was correct, Rangers argued that Sports Direct could not use their contract rights in a way that would give it control over all of Rangers' supply chain and thereby prevent others selling Rangers' football kit. Now, this later case is clear in its conclusions and clear in its rejection of Ranger's arguments, but neither the judgment nor those arguments refer to the earlier Post Office case and the reasoning that applied there. Nor does this later judgment go into any detail to refute Ranger's argument that contract was relational. Instead, it simply focuses on the correct test for implying terms into a contract as a matter of fact, and then applies that test to Ranger's proposed implied term. This test was set out in the 2016 Supreme Court decision of Marks and Spencers and BNP Paribas, and can be summarised as saying that a term will only be implied if that term must be necessary to give business efficacy to the contract, so that no term will be implied if the contract is effective without it, and no term will be implied if it contradicts any express term of the contract. The approach of this latest Rangers case by the judge was to treat the matter simply as one of contract construction. The judge said that an implication of a duty of good faith will only be possible where the language of the contract viewed against its context permits it. It is not a special rule of interpretation for this category of contract. On this basis, the judge rejected any basis for implying a term of good faith into the arrangement, as the implied term Ranger suggested was not obvious, it was not necessary to give business efficacy to the agreement, and it cut across express terms. Or, to put it another way, if the agreed commercial terms gave Sports Direct control over all of Ranger's supply chain, then those were the terms that had been agreed and were nothing to do with any exercise of bad faith on the part of Sports Direct. So we now appear to have two approaches from first instance cases as to whether a duty of good faith will be implied. One that approaches the issue with an emphasis on the Supreme Court approved restrictive test for implying terms as a matter of fact, and the other using an approach that first categorises a contract as relational and, having adopted that category, implies a standard of behaviour into the contract without looking at the test of business efficacy. So we're left with a potentially confusing position. If you have a long-term collaborative contract that could be categorised as relational, do you approach it on the basis that an obligation to act in good faith will apply to your actions, or do you assume that the restrictive test on implied terms will apply and ask yourself the question, does the contract work without the term? One solution might be to expressly exclude any obligation to act in good faith either absolutely or excluded on the basis that the contract contains its own express terms on how parties should act in particular circumstances. However, one further word of warning. Including an express term to act in good faith is not necessarily going to add much clarity as to the extent of behaviour required to comply with that term. So we now reach the end of our commercial law update for September. I hope you've enjoyed listening to this, and please contact either myself or Sarah or your usual contact at Eversheds Sutherland if you have any queries. Thank you very much.